Obiter is a legal term which describes the asides and hypothetical principles that a judge includes in a judgment. Welcome to Obiter, a lifestyle show that explores modern lives. My name is Richard Smithers and my co-host is Brian Sanya. With us are a series of special guests with whom we'll be discussing law, society and economics. The first episode starts with a subject I find interesting: Indigenous land and property rights. We'll be looking at how we define those rights, how and where Indigenous First Peoples have been influenced by colonialism, and the application of remedies such as litigation, reparations and decolonisation. Echoes of these themes have contemporary relevance in Black Lives Matter and the removal of the Queen as head of state in Barbados next year. Firstly, we need to define what we mean by Indigenous. The terms Aboriginal First People, Indigenous and Native are not synonymous, and we'll prefer the term Indigenous throughout. Although the definitions are contested, we'll consider the United Nations conception. The UN guidance suggests that Indigenous people identify themselves and their community as such. There's a historical continuity, a strong connection to a particular territory, and an identifiable set of cultural and social values. What is property? Well, we can break it down into four distinct types of things. Each are capable of giving rise to certain rights, such as ownership, transfer to another, and they enable the owner to exclude others from it. Firstly, we have movable items, such as a car, immovable items, such as a house with land, intangible rights over things, for instance, trademarks, and other interests in property. It's a doctrine which suggests that land that's occupied and used by Indigenous peoples has not been claimed by anybody. In other words, it's vacant. So, for instance, the Taikotin in British Columbia, they hunt and fish on the land, and it becomes a community resource where everyone benefits from it. But they haven't actually specifically made a claim because they never needed to register land. So this legal fiction was used to dispossess native people.
You take someone's property, you say they don't have property, then you acquire rights over it, and then you grant it to someone else. How legitimate is that?
Proudhon and Brissot both formalized and developed the idea of property as theft, really with the question of how is property acquired in the first place? And it can only really be acquired through a limited number of means. One is that somebody makes a claim on property where there was no pre-existing claim, or they acquire it through conquest and appropriating that property from somebody else, or else through succession, or of course by selling it or bartering that property. It's quite interesting to look at John Locke's concept of what makes property moral, that if you have a close association, essentially property ownership is the fruits of your labour, then it becomes moral to own property on that basis. Actually, when we look back at Indigenous people, there's a greater morality when we examine the way that the land was used, to whom it benefited, and how sustainable that land use actually was.
There's this judge in America called Justice Marshall, and he says leaving the land to the natives is literally leaving the country to become a wilderness. Now, Richard, take us back to Australia, because I know there's the leading precedent in the case of, is it Mabo or Mabo?
So it overturned terra nullis, which is the most important aspect of Mabo. So it was a real turning point for the concept of terra nullis, firstly, and for native title, that native title could exist as long as it hadn't been extinguished. But what it actually meant was a fairly narrow reading of the rights that should then flow back to Indigenous peoples.
Like, every jurisdiction had some sort of recurring theme, okay? So we are in Trinidad, for example. The Amerindians have been cautioned away in a place called Arima. They've been given 25 acres of land, and that's where they belong. So the rest of the country is either state land or private land. So you natives go sit in that corner. In Belize, the same thing happens. The Mayans in Belize have been squeezed into that sort of corner.
I think the common theme that you describe reflects the experience of similar interests and methods being employed over centuries by the dominant colonial powers.
Some of these countries, let's say, is it Canada, and I think Kenya as well, they try to implement indigenous rights into constitutions. So how does the constitutional position apply?
Certain Aboriginal rights are enshrined into Section 35 of the Constitution Act 1982 in Canada. And so that provides certain land rights. It's quite vague about what existing rights actually means, but it demonstrates that a fiduciary duty is owed by the state to Aboriginal people, and that Aboriginal people have a right to be consulted regarding permits, approvals, and mineral rights that are provided to companies and individuals.
Okay, now, in 2007, Richard, we have the UN coming to intervene with the United Nations Declaration on the Rights of Indigenous Peoples, the UNDRIP Treaty, yeah? So what's really happening that's making people not want to be part of the treaty or part of the declaration? Is it urbanization? Is it commercialization? Is it agriculture? Is it? What's really happening out there?
Well, there's a conflict between two broadly irreconcilable sets of values. Firstly, modernity, with the concept of the freedom of the individual to acquire property rights, versus the second, a collective community existence where shared stewardship of property is more of a norm.
In terms of remedies, I know you've mentioned that there's reparations and there's litigation. But I take issue with litigation, first of all, because in some of these jurisdictions, as I mentioned again, it's the law that took away the people's rights. So how is it possible for the same legal system that took it away from you is the one that's coming to give it back to you?
So the legal systems were partially engineered, and this was accepted in Mabo, engineered to suit the circumstances to favour the settler.
And Richard, as a lawyer who practices intellectual property law, I think the legal framework as it is now cannot even support the traditional aspect of IP when it comes to indigenous rights. Because how, let's say, the law of patents and trademarks and copyrights has been curated now, it's impossible for the modern aspect of law to go back and cover retrospectively, because how those rights came about, how that knowledge was passed down, you can't find one particular author. It's a collective. I'm from Africa, you know, I'm from Kenya. Big up all the Kenyan viewers on the show. Now, land is big in Kenya. It's a big thing, I think, in the whole of Africa. And there's lots of cultural and traditional value when it comes to land and property, let's say owning cows and goats and all those things. So the people's identity in Africa is linked to the land, okay? So it's a source of livelihood, wealth, social peace, everything, name it. It's religious, it's literally everything in Africa. So now comes in the colonialist, and you strip away the man of his name, you rename him, whatever name, you strip his values, you tell him he's nothing. Because if you read what General Ian Smuts in South Africa says, what is urgently wanted is the settlement of a white population, able and competent to undertake the task of development, and finally, to conquer and hold this continent for European civilization.
I think it's interesting to look at the damage that's caused by forced assimilation. For instance, the stolen generations in Australia. where children were forcibly taken from their parents, effectively indoctrinated, their culture erased, and this attempt to try to assimilate them into the mainstream culture. There's another example in the US with the Dawes Act, which was an attempt to assimilate Native Americans into European norms. That involved also land confiscation and sending children to boarding school.
You've mentioned Barbados and the intention to drop the Queen as the head of state next year, 2021, right? However, I still find that post-colonialism, the indigenous people are still going through trouble, and the trouble is being furnished by their own republics. You'll see the problem is even beyond colonialism, and it's the governments that are really pushing the indigenous people to a corner somewhere in the country and saying, you don't have the rights. We want to invest, we want to bring money to the country.
What are the difficulties for former colonial states in terms of accepting reparations or remedies from the former colonial masters?
Well, Richard, I think that's a very dicey situation when it comes to reparations, because you have some former colonial powers who don't want to. It's a really embarrassing position for them. So maybe offering an apology or offering something tangible, like a tangible investment. So we'll come back, what we took, we'll bring back. We are going to invest in terms of infrastructure, hospitals, whatever. We need practical reparations. We don't just want cheap words and promises or it is what it is. No, we want to see tangible stuff. What do we do when it comes to artifacts and things that were stolen from indigenous peoples? Do you think the museum should return this? I think the other day I saw an article on the BBC, some activists from DRC Congo went into a Dutch museum and stole something back that was supposed to be from their mother country. What do you think? You come into someone's country, you colonize them, you take their stuff, and then you put it in your museum, and you don't want to return it. Like, how do we reconcile that as well?
Well, going back to the concept of property as theft, well, that theft has become property.
Right. Catch you later. Catch you next week. More exciting content, more exciting guests coming on. So thanks for tuning in.